Hi, everybody. Jean Humbrecht with Humbrecht Law here, criminal and traffic defense attorney in Manassas, Virginia. Welcome to my weekly local business spotlight. Today I have a very special guest, Corrie Sirkin from the Sirkin Law Firm. Corrie practices family law and her office is located in Manassas, Virginia. Corrie is an awesome attorney. She really knows her stuff. I would not hesitate to refer her to anybody who has any issue with family law, divorce, custody, visitation. But there's a lot involved with all that stuff. So I'm going to turn it over to Corrie right now to tell everybody a little bit about her background and business, and then we will just I'll chime in with questions as I think of them. And I also want to invite anybody watching this, feel free to type a question in the comments and we'll try to get to it. And if you're watching the replay later, still feel free to type something in there and we will definitely get back to you. So Corrie, I'm handing it over to you.
Thank you. So I'm Corrie Sirkin. I've been exclusively a family law attorney for 10 years. I do divorce, custody, like she said. I'm also a child of divorce with remarried parents and a divorced mom. So I can really understand what you're going through from your kid's perspective, from an adult perspective, and also from the perspective of an adult with divorced parents. So lots of things going on there. And we're really lucky to be, able to amicably kind of all be a big blended family together. So I practice exclusively family law. I help people during one of the most difficult times of their lives to transition from where they are to what their new future is going to be, whether they chose that themselves or whether their spouse or other loved one has decided to end the marriage or to make changes to custody, parenting time, things like that. So
okay, well, so can you talk a little bit more about specifically the services that you provide for somebody that might not know? Like, let's say somebody has never gone through this before. If they find themselves in a situation where the marriage is ending, what are the different things that they need to think about?
So there are different options in family law if you're going through a divorce or a separation. You do want to talk to a lawyer as soon as possible when you're thinking about it, considering it, or somebody has told you that they, want to separate, because you may not know even what a separation entails in Virginia. You can be separated in the same household, which is a question I get all the time. And they're like, well, what does that look like? And it looks like you guys are not acting as husband and wife, or wives or husbands, and you're not doing things for each other. You're not going on dates exclusively. You're not cooking for each other, cleaning for each other. But when you have children, you're still going to have to do the things for kids, and you're still going to want to have as normal as possible of a life for your children, even while you're going through this. You're going to sleep in separate bedrooms. You're not going to engage in marital relations. So these are the kind of things that an attorney can kind of talk you through, what you can do and what you shouldn't do with your bank accounts and credit cards and things like that. So that it's fair and legal. So, yeah.
So can you tell everybody a little bit about the difference in getting divorced if you do not have kids or if you do have kids? Because people, I'm familiar with this on a very, very basic level. People might not know, what the custody and visitation part and what that entails, and all the things that need to be spelled out.
Right. So custody and parenting time is very particular. If you don't have children, then it's a little bit, it can be a little bit easier in Virginia to get divorced because you don't have to have a 1-year separation period if you don't have children. It's a 6 months, but that's with an agreement. So it still can take an extended period of time with the separation period, and then the time that it actually takes to go through the court system if you have to actually, in fact, litigate. So with custody and parenting time, those orders can be as different as every family. So, one family, Thanksgiving is really important, and you always go to to your nans or your grandmas or something like that. And every Thanksgiving, the whole family gets together, and that means the whole Thanksgiving weekend. You're traveling, somewhere or something like that. That's your family's tradition. If you choose to litigate, or you can't come to a reasonable resolution through the collaborative process, mediation, or negotiation, then a judge is going to make those kind of decisions for your children, just blanket decision. So, Thanksgiving with mom every even year, Thanksgiving with dad every odd year. It can't be as tailored to your specific family as these other processes, which allow you to control what your final agreement looks like. But we get down to the nitty gritty. I mean, you're going to pick up the children on Friday at 5. There's going to be the transition period. Who's going to drive? Where you're going to meet, as specific as you guys need the agreement to be. It's better to be more specific and to have that written down versus people who are trying to work things out amicably, but they don't have a fallback if they can't agree to something. So let's say somebody's work schedule changes and they can't get there at 5 o'clock, and all of a sudden there needs to be some kind of like childcare or something like that. If you don't have the agreement where it says who's responsible for what when, then you can get into a situation where it's just a back and forth, and it's not good for for anyone. Circumstances change, and you want your agreement to be specific but flexible. And parents can always choose what's in their kids' best interest within reason. So if you decide that Fridays don't work for you guys anymore, and instead your transitions should be on Mondays, you guys can do that as long as you agree. And normally, if you have a written separation agreement, as long as you put it in writing, you say, okay, we are changing our dates to Mondays at 6 or 5. And the other person says, yes, I agree. And that can be a text message. That's, fine. So, but, going that process is a lot better than, and kind of figuring things out for your specific children and their situation is a lot better than having somebody impose it on you. And, as Jean, trials aren't very long. Even in our area of the law where we do get a little, involved, 1-day trials, you're 7 hours, not even because of breaks and things like that. 3-day trials are kind of the biggest that they ever give us. And, 3 days is not a long time for a judge to learn you and your family and your children, so that they can make the best possible decision for all of you. So going through some other process to, make those decisions for your guy, for the two of you and for your children is often the best way to go. And it's more economical.
So. That is true. Yeah, if you can avoid going to court, the better.
I'm a mediator and a collaborative lawyer. So people don't really know very much about collaborative law and divorce. Collaborative law is where each person has their own attorney, but you agree to go through the collaborative process where the attorneys aren't in a complete, we're working in a team environment where as a team with both spouses and the two attorneys and potentially a mental health expert or a child development expert, as well as a neutral financial person, we look at the entire situation and work together to come up with a plan that works for everyone. The collaborative process is something that you have to agree with, both parties have to choose, and then you sign a contract where you're going to continue in the collaborative process, and you're not going to litigate. And if you do decide to litigate, then your attorneys withdraw from being your attorneys in the collaborative process, and you have to choose different litigators for your divorce.
Oh, that's interesting. I didn't even know about that.
Yeah.
And I would think that you probably would want to avoid that for a number of reasons. But if you have to have a new attorney jump in when it gets to the point of going to court, that attorney has not worked with you from the beginning. And yeah, we can all as attorneys do our best job to catch up, but it probably would be best to have the same attorney from start to finish if possible, right?
Yeah, well, but with the collaborative process, your perspective is that of the team perspective, where you're looking out for your client's best interests and you're giving them legal advice and you're helping them with the process, but you're not in the litigation mentality. So in a litigation mentality, with custody and parenting time, if it's really hard fought, then you're going to have to say everything that other parent ever did wrong in order to try to prove that you're the better parent. That's just unfortunately kind of how it goes. In a collaborative process, you can work with a developmental psychologist to say, okay, this is the constraints of your work schedule, and this is the constraints with the kids. And they kind of work with you to come up with something that really is, the best solution for everybody based on the changing dynamics. At the same time, for financial neutral, in a litigation process, you have your set of interrogatories, questions, and requests for productions and documents. So, your attorney is going to get those documents. And then you pay your attorney to go through all of their information and to go through all of your information. With financial neutral, we as attorneys don't have to go through every single document. The financial neutral goes through both documents. It's full and fair disclosures. And then the financial neutral can run scenarios based on what my client's concerns are and what the other client's concerns are. So my client is like, my mom is 98. I think I'm going to live to be 110. Then that financial neutral can run those scenarios to make sure that, based on how much they're spending, whether they might need to downsize, how much money they have in reserves, whether they're going to be able to live comfortably to 110, or whether we might have to have some kind of, different plan. If you pay two separate attorneys to do all of that discovery versus one financial neutral to do it, there's a lot of economies in having that joint financial neutral. Plus, in Northern Virginia, if you pay in Northern Virginia, most financial neutrals are actually less expensive hourly than attorneys. So you get that as well. And the attorneys, if they have any questions or concerns about documents or want more information, then they can just say to the financial neutral, like, oh, well, I see this statement, this most recent statement, but my client thought there was more money in that. Can we get the statement from, can the other party request the statement from 5 years ago so we can see what's happened in the meantime? Which is much more, economical than like having to go through subpoenas and, and getting, I subpoenaed 5 years of records recently and got 2,500 pages of, of checking and savings accounts. And the banks charge for that too. So everything has a cost. So.
Yeah, and while we as lawyers can read very fast, it still takes a long time to go through 2,500 documents.
Right, yeah. We were looking for like big withdrawals, like weird transfers, accounts we don't know about. We're not looking at every single page, but sometimes when you add up like, every single time that you went to the ABC store, it creates a very different picture than than what what you think. So, yeah.
Well, what would you say to people? Because I've come across this a lot. What would you say to people who do not want to hire or consult with a lawyer because they and their spouse agree, and things that seem to be as amicable as possible, I should say. They're all in agreement. They don't want to fight. They have a plan for when mom is going to get the kids and when dad is going to get the kids, and they find a document on LegalZoom or whatever it is. What would you say to people who want to go that route?
So an attorney doesn't have to be really expensive. But if you make mistakes in your agreement now, you're waiving those rights forever. So you really do want to talk to an attorney, get some information, get legal advice. Lots of people are amicable in the beginning, and that's a great time to have the conversations about what are we going to do. And you can go to a mediator who can help you write an agreement that goes over all those things. It's going to be way better than LegalZoom because they're used to Virginia law and they understand. But when it comes to, and there are divorce pro se packets, Prince William and Fairfax have their own packets, but I have fixed a lot of issues with those packets. So they're written in very legal terms. They don't give you any kind of legal advice, and they're difficult for a lot of people unless you're literally asking for kind of nothing. You just want out of the marriage. So when it comes to a more defined plan, you also want a more defined plan with a lawyer, because when things aren't going great. So let's say one person gets into a new relationship and it's with a person that makes emotions flame. So let's say, wife is dating husband's best friend, or vice versa. Husband is dating wife's best friend. After they're, separated, it can be really difficult to continue to have that amicable situation if you haven't put it in writing, if it's not enforceable, because those feelings do, cause people to act differently, or it can just be different, difficult transitioning to a more blended family. It can be 5, 6, 7, 8 years down the road, and your ex-spouse is getting remarried, and they want to change the schedule so that it better fits their new blended family, where they have, the kids from both families at the same time, so that they can be, siblings and get to live together and grow together. It's going to be really difficult. Sometimes it will be really difficult to do that without having some kind of background, document. And in Virginia, you have to prove that there's a material change in circumstances. If you do have a document, well, if that document doesn't say what the current circumstances are, how are you going to prove that there's been a change? It's just a he said, she said in a situation. So, whether it's a mediator, the collaborative process, you can do it yourself. I also offer a divorce clinic. So I wanted to kind of help these people who really want to do things themselves, but maybe need a little bit of help on filling out the forms. And so I offer a divorce clinic where I'm not going to be the attorney on the case. So it removes me from the risk of, being the named attorney, but I can help them with forms. So, there's this VS4 form in Virginia that's very difficult. It needs to be in black ink and no strike throughs, and all the information needs to be in there, and you have to put the right thing in the right places, or else you get it rejected. Same thing with a final decree of divorce. I had a client recently who came in and she had done it herself, and she had done a good job, and she had a master's degree. She was a very smart client. And she had her final decree of divorce rejected 4 times. And she's like, and the law clerk can't give her advice. The court clerk can't give her legal advice. So she came to me and she said, okay, what do I need to do? And she was missing one sentence, but it's an important sentence and it's required under the statute. So I showed her where the sentence was. And then I said, okay, after this, you're going to have an ora tennis hearing where you and your witness are going to go, and the judge is going to ask you questions. She was like, I have to take another day off from work. And I said, or if you want, I can correct your final decree of divorce, do your plaintiff's affidavit, your witness affidavit, your VS4 form that you need, and submit it all to the court for you. And you don't ever have to appear in court. Those things just need to be notarized and provided to the judge. And then we'll be done. And for just a couple hours of my time, we were able to finish everything. Whereas with the ora tennis hearing, she would have had to, put it on a motions date and then return for an ora tennis. She would have had to take 2 more days off of work to set things up when, very expensive to just finalize her divorce. And Virginia is very specific. Each county has their different requirements. I have literally had a waiver and acceptance that was accepted in 6 counties and jurisdictions be rejected by 1 jurisdiction because they have their own way of doing things, their own language, and even their pro se packets, or even if they don't have one, it doesn't have that information. Only an attorney that practices there locally can kind of give you that, insider information. So.
That's actually a really good point, because I tell people all the time, regardless of whatever your legal issue is, that you should consult an attorney who is local or who practices in that courthouse that you need to be at, because they all have their nuances and rules. And, sometimes if something is messed up, it could have catastrophic consequences on the case. But most of the time not. It's just more of an inconvenience of having to do something again or come back again. And nobody has time for that. I mean, we all have to work. So, you said something that I actually wanted to ask about. You were talking about the orders, having everything in writing about, who's going to take the children when and all that stuff. Now, during the shutdowns and COVID and everything, has anything changed? Have people, because obviously this has never existed, so there was no way this could have been in a document. What if one parent did not want to send the child back to the other parent, not because of anything that person did wrong, but because, like, let's say mom doesn't want to send their child back to dad because she doesn't think that dad is going to take precautions, or for whatever reason she doesn't feel safe sending her child back. Can she do that, or do people still have to abide by the times and dates that are in those agreements?
Yeah. So, like normal attorney answers, it depends. So overall, the one of the Supreme Court orders said that there were one specific exception when it comes to the stay in place orders and things like that was custody and parenting time transitions. So, the judiciary and and the governor were aware of the fact that these things do come up. Mm-hmm. Now, if you have high risk people in your family, high risk children, if you have information that someone is not abiding by the guidelines and things like that, then it could be a situation where the court could agree with you that it's not in the children's best interest to be with the other parent. And for people who, and I've had in other cases where people were in one household, were told that they had been exposed. So in those cases, especially, the guidelines were 14 days where they are, quarantined, and in those cases, it was cut and dried. Like, you were exposed. We have to wait 14 days before you can do, custody and parenting time. But in most of the cases, we were able to, do makeup time, switch weekends, things like that accommodated that. But for people who really, had that high risk and things, you could certainly motion the court for it. But overall, unless you have high risk or some specific real reason, the overall people are expected to keep to their custody and parenting time orders, even in the age of COVID. So I would probably say that the vast majority of cases are going to be, at least locally, the judges expect you to stay with your current custody and parenting time orders, unless you do have some kind of high risk issue or something like that that kind of puts you outside of the norm. So,
have you come across that at all over the past few months from either side?
Mm-hmm. Yeah. I mean, like I was saying, recently, one of my clients was notified by her ex-husband that there had been a potential exposure in his household, and he told her pretty much as soon as he knew. And, we counted the days and agreed on a new transition time and things like that. I have had, clients with really specific concerns and risk factors who, have withheld the children. But in those cases, we're also looking at ways to kind of make things up. But obviously our information was very different in March and April than what it is now. I mean, we were thinking that pretty much everybody that had a coronavirus was a super spreader, because we had heard these anecdotal cases of, one person being, getting 25, 30 other people, sick because of this. And we didn't know whether that was everybody who was sick with it or, a smaller percentage. Now that we have more information, there's more science, and we can make kind of better decisions. And I think our judges have more understanding of, where we are now. So
that's true. Now, if somebody would want to go into court to change an order, or let's say somebody unfortunately is going through a divorce right now, or has an issue that's completely unrelated to COVID, are the courts, in terms of what you do, are the courts open as normal? What can you tell us about what people can expect if they need to do anything in court for any part of this process?
Expected it'll take longer than it did in the past, but most people don't have any frame of reference when it comes to how long these things happen, because as a family law attorney, normally I don't have repeat customers. I have referrals, but I do have some, but like normally people, it's one of their few times involved with the court system when they're going through this process. So expect for it to take longer. I was at term day yesterday, and there were still a few available non-jury dates, which is what we say for you're going to get a judge to decide, that were available in the next few months. But most of the availability was 4, 5, 6 months out, and we don't know whether those delays are going to be compounded. Because right now our courts are having smaller dockets so that it allows for more social distancing, and they're having fewer cases set during a day, so it's taking longer to get through the backlog. But there are all these other options that you have instead of litigation to go through. I mean, you can mediate with a mediator or with a retired judge. You can do arbitration. The courts are still open, though. If you need something, we can get an emergency hearing within a month or so, depending on what kind of emergency it is. It could be quicker. But overall, it's taking longer, but our courts are open. They're doing the best. But you kind of have to prepare for the worst and hope for the best, because any one of us could show up at the courthouse, and when they put the thermometer against your head, hold it out to get your temperature, that temperature reads over 99, you're not going to be allowed inside the courtroom, the courthouse. So what do you do? The good thing is we have a liberal continuance policy still in effect. So if that happens, or for you or your client, you can make arrangements. But if you're sick ahead of time, tell your attorney ahead of time so that we can, notify the court, notify the other attorney, because you could be responsible, for somebody else's legal fees or something like that if you weren't conscientious, or you don't know. So
yeah, that's a really good point. Yeah, I go to court almost every day now, and they put the thermometer to my forehead every day, and I'm normally like, please don't let me have a temperature. I got to get some stuff done.
I actually bought a thermometer for my office, so before I leave, I pick it up and go, okay, all right, I'm good, and make sure my AC is running in my car, so I'm not because I had a friend who got there and decided to walk and didn't realize it was so hot, and their temperature ran just like 99.0, and they're like, I'm really hot. Okay, can you wait like a couple of minutes? And the sheriff's officers were awesome. They're like, okay. She sat there with her mask, and then a couple minutes later, she was like, okay, try me again. I think I'm cooler. And they took her temperature, and it was fine. But, and be prepared with your mask. Like, you're not getting into the courthouse without a mask, and they don't have, PPE for people. People who need interpreters, I actually have invested in a couple of face masks for my clients, because if the interpreter is trying to listen to them and listen to the judge, and sometimes my client is trying to read the interpreter's face as well, the face masks really help with that. And and they're acceptable as as an option for the court. So.
Do you mean the see-through masks?
Yeah, the ones that kind of come off.
Yeah, I know what you're talking about. Okay, I've seen the interpreters wear those. Yeah, that's actually a really good idea, and I didn't realize how much I actually read lips until I'm not allowed to. Well, to see what people across the hall say.
And just like, somebody says hi to you, and you're like, in the courthouse, and you're like, oh, hey. You just don't know.
I still smile hello to people, and then I'm like, why did I do that? Like, maybe they see in my eyes that I'm smiling, but I guess it's good. You have to now you're forced to say hello to everybody, right? So it's probably a good thing.
Yeah.
Okay. Well, I know there's so much that you could talk about, but is there anything else that you think people should know about, what it is that you do, or things to keep in mind if they're going through anything, or about the court process, just anything before we go?
So, it seems like an expensive proposition to pay an attorney for a consultation. But if during that consultation you get just even a little bit of advice that helps you in the long run to make the best decisions for your family, then it's totally worth it. There are nuances to cases and things that you're not going to think of, that attorneys are used to. Read the blogs. Don't listen to your cousin or your brother or your friend or your aunt or something like that. Every family is really different. You can have two similar situated families where both husband and wife have worked for the same companies, and they live in the same size house as their neighbors, and from the outside, everything looks the same number of kids, same age, all that kind of stuff. There's all of these things going on behind the scenes that you don't see from the outside that make a big difference in spousal support and child support, custody, parenting time, equitable division of assets. Two neighbors on the same street making the same amount of money. One person has $100,000 in debt, and the other has, their house is paid off. You look very the same from the outside, but from the inside, the decision that the court's going to make for you and your family are going to be, really different. So having the advice of an attorney, even if you're going through one of these outside processes or you have an agreement in mind, consulting with an attorney to say, okay, this is what we're thinking. Are there any things we're not thinking of? It's really, it benefits the vast majority of people in a real way to have some legal advice, even if they decide to do something different in the end. So.
Yeah, I completely agree. And it's always best to go in with as much information as possible to make an informed decision and know, what you're risking and what the consequences are of all the different actions. So that's very true.
Yeah.
Well, Corrie, I'm going to ask you to put your information in the comments. So if anybody wants to get in touch with you, they can. And then also the information about that clinic that you mentioned, because I think that would be really interesting too, the divorce clinic.
Yep. And it's VA Divorce Clinic on Facebook and Sirkin Law Firm on Facebook, and I have blogs and other information about things, and I'm happy to answer questions. So yeah.
Okay. All right. Well, Corrie, thanks so much for joining me today. I really appreciate your time. I know you're a very busy lady, so thank you.
Well, thank you. Have a good one.
All right. Bye.
Bye.